Hello and welcome to the Colorado Real Estate Harder Questions Exam Practice. Must know prep material to help you pass. Video 2. Question 1. In a promissory note, an acceleration clause, A, allows a borrower to convert from quarterly to monthly payments. B, allows a borrower to pay off early without a penalty. C, allows a lender to call the remaining balance due if certain events happen. D, allows a lender to refinance a balloon payment when due. The answer is C, allows a lender to call the remaining balance due if certain events happen. For example, non-payment of loan, non-payment of taxes, or hazard insurance if not escrowed. Question 2. What form may earnest money take? A. Cash or good funds only. B. Cash or check only. C. Cash, check, or promissory note. D. Any form the seller will accept. The answer is any form the seller will accept. The earnest money can take any form that is agreed to by the parties. Question 3. In Colorado, the most common instrument used to secure a real estate loan is mortgage, B. Deed of trust, C. Installment land contract, D. Chattel mortgage. The answer is B. Deed of trust. Colorado has passed legislation making us a deed of trust state and established the office of a public trustee in every county. In some small counties, the treasurer may take this responsibility. Question 4. How long may a landlord hold a tenant security deposit after termination and surrender of the premises? A. 30 days unless the lease calls for a longer period up to 60 days. B. Never more than 1 month. C. 30 days unless the lease calls for a longer period up to 75 days. D. Only until any damage has been repaired and charged. The answer is A. 30 days unless the lease calls for a longer period up to 60 days. The longest period a landlord may hold a deposit is established by law at 60 days. Question 5. Under Colorado law, if you do not have a written agreement or a specific disclosure with a party to a transaction, you are considered to be A. Agent for a seller, B. Transaction broker, C. Agent for the buyer, D. Dual agent. The answer is transaction broker. Without an agreement or disclosure, you are considered to be a statutory transaction broker under licensed law. Question 6. A counter proposal. A. Accepts the offer and requires changes to all the terms. B. Contains a completely new agreement. C. Must be accepted by the acceptance deadline of the original offer. D. Must be securely attached to the original offer. The answer is must be securely attached to the original offer. Since the counter now supersedes the offer, it is attached on top of the offer. Question 7. If the seller and buyer have a legal dispute regarding the approved contract to buy and sell real estate, what must they do? A. Submit the matter to binding arbitration. B. Interplead the earnest money to a court of competent jurisdiction. C. Submit the matter to mediation and seek resolution within 30 days. D. Submit the matter to binding mediation by the Real Estate Commission. The answer is C. Submit the matter to mediation and seek resolution within 30 days. The contract determines that before parties can arbitrate or litigate, they must first submit to mediation. Question 8. The approved agreement to amend and extend contract. A. Amends a contract to buy and sell. B. Amends an exclusive right to buy listing contract. C. Amends an offer to purchase. D. Amends a transaction broker addendum. The answer is A. Amends a contract to buy and sell. This form changes or amends the original agreement. Question 9. If no general property taxes have not been paid as of March 1st, what is the latest date they may be paid to avoid any interest or penalty? A. The last day of March. B. June 15th. C. The last day of February. D. The last day of April. The answer is D. The last day of April. Question 10. The Commission-approved seller's property disclosure form A is required by statute. B is required in all residential sales. C is required by a provision of the residential contract to buy and sell. D is required to be completed by the listing broker. The answer is C, is required by a provision of the residential contract to buy and sell. If the seller chooses not to use the disclosure form, the seller must state so in the listing agreement and counter the contract to buy and sell. Bonus question 1. Buyer and seller shake hands on a transaction for a house at $300,000. The contract is A. Illegal, B. Voidable, C. Unenforceable, D. Express. The answer is C. Unenforceable. Question 11. Lead-based paint disclosure is required. A. For property built before January 1st, 1978. B. For all residential sales. C. For property in known high lead areas. D. For residential property in which a building permit was issued before January 1st, 1978. D. For residential property in which a property permit was issued before January 1st, 1978. The lead-based paint disclosure form states a residential property built before January 1st, 1978, but Colorado is more specific. It states all residential property in which a building permit was issued prior to January 1st, 1978. Question 12. What is the purpose of the broker's signature on the sale agreement? A. Broker is a fiduciary and therefore is a party to the agreement. B. Broker confirms the commission split between the cooperating brokers. C. Broker receipts for the earnest money and confirms the brokerage relationship. D. Broker is witnessing the legal document for the buyer and seller. The answer is C. Broker receipts for the earnest money and confirms the brokerage relationship. The broker's signature is listed below the end of contract because the broker is not a party to the agreement. The Colorado's Uniform Consumer Credit Code, UCCC-A, requires creditor-lenders to charge 21% interest. B. Allows a creditor-lender to charge up to 45% interest on most loans. C. Requires creditor-lenders to charge higher interest rates for business loans. D. Allows a creditor-lender to charge up to 25% interest on most loans. Answer is D. Allows a creditor/lender to charge up to 21% interest on most loans. The Colorado Statute of Frauds attempts to limit fraud by A. Requiring that a real estate listing be in writing. B. Requiring that certain types of documents be in writing and signed in order to be valid and enforceable in court. C. Requiring that agency contract be in writing. D. Requiring that certain types of documents be in writing, signed, and witnessed in order to be valid. The answer is B. Requiring that certain types of documents be in writing and signed in order to be valid and enforceable in court. Any agreement written to convey the title of real property must be in writing and signed to be enforceable. The purpose of Commission Rule F relating to approved forms is to A. Help ensure the broker's compliance with the Conway-Bogue decision of the Colorado Supreme Court. B. Assist attorneys in handling real estate transactions. C. Require that all real estate transactions be completed using the same form. D. Prohibit the use of addenda to add material to standard forms. Answer A. Help ensure the broker's compliance with the Conway-Bogue decision of the Colorado Supreme Court. Real estate licensees are allowed to limit practice of law by filling in blanks in standard and approved forms. Question 16. A broker, seller, and buyer all agree to provide two contracts at different prices. The higher price contract will be used to apply for financing and the lower will be used for a closing. A. This is fraudulent dual contracting. B. This is legal since all parties agreed on. C. This will likely result in a higher loan amount. D. This is appropriate in a rising value document. The answer is A. This is fraudulent dual contracting. By giving a higher purchase agreement to the lender, the buyer could get a loan with no money down or a lower down payment. Question 17. When a seller receives an offer from a buyer, the seller may properly respond by A. Checking the appropriate box, initialing the form, and submitting a counterproposal. B. Telling his or her broker to call the buyer with a counteroffer. C. Writing rejected at the top and signing it at the bottom on the appropriate seller line. D. Telling his or her broker to call the buyer with his or her acceptance. Answer A. Checking the appropriate box, initialing the form, and submitting a counterproposal. May, in the question, would state that this is the only one of the options available to the seller. Question 18. If a seller is offering seller financing, A. The buyer may set the interest rate. B. The listing and sales agreements should specify the type of note and deed of trust. C. The broker must use Fannie Mae forms for the loan. D. Only an attorney for one of the parties may prepare the forms. The answer B. The listing and sales agreements should specify the type of note and deed of trust. This is found under the section Seller Financing in the contract to buy and sell. 19. Your sellers had a radon done when they bought 6 years ago. The test showed action levels of radon on the basement storeroom only. They showed A. Disclose the test results and the age of the test. B. Disregard such an old test. C. Keep a basement window open during the test. D. Have a new test done now. Answer A. Disclose the test results and the age of the test. If the seller had a test done, the test results must be disclosed with the age of the test. A seller completing the seller's property disclosure form tells you the air conditioning hasn't been used in 3 years. How should they mark the form? A. Working, since that is the last they knew. B. Not working, since it has been so long. C. Not included, since it may not be working. D. Do not know, or working with a note about the time. Answer D. Do not know or working with a note about the time. This disclosure is answer to the seller's current actual knowledge. Bonus question 2. A buyer's final inspection usually performed before closing is called A. Due diligence. B. Due on sale. C. A walkthrough. D. A punch list. Answer C. A walkthrough. 21. The schedule of exceptions in a title insurance commitment. A. List things to be done before the policy will be issued. B. List things against which a company will not insure. C. List things which make the title unmerchantable. D. List items that will not be replaced if damaged. Answer B. List things against which the company will not insure. 22. One approved deed of trust provides for strict due on transfer. This means the lender may call the note due. A. At any time. B. If the property is transferred under the borrower's will. C. If the borrower sells the property. D. If the borrower changes employers. The answer is C. If the borrower sells the property. In this case, the deed is not assumable and must be paid in full before the title can be conveyed. 23. When a deed of trust is used for financing, the beneficiary is the A. borrower, B. broker, C. public trustee, D. lender. The answer is D. lender. The borrower is the trustor, the public trustee is a trustee, and the lender is the beneficiary with a three-party deed of trust. Title to the property may be acquired by adverse possession if A. the property has been unoccupied for 18 years, B. the claimant has lived on the property for 7 years, C. the claimant has occupied the property for 18 years under certain conditions, D. the claimant has used the property for access for 18 years. Answer C. The claimant has occupied the property for 18 years under certain conditions. The time frame varies in different states. In Colorado, the 18 years may be reduced to 7 years if the claimant paid the taxes or purchased under color of title. The seller under an installment land contract A has full real property rights, B can foreclose at any time, C retains legal title, D retains equitable title. Answer is C, retains legal title. The buyer has equitable title, but doesn't receive the legal title until the terms of the installed land contract are met. Bonus question 3. Brokers may submit A. listing agreements, B. purchase and sale contracts, C. auctions, D. all of the above. Answer D. all of the above. Thank you for watching. I hope the questions were beneficial to you. If you would like to see more like it, please like and subscribe. Don't be stumped by the tricky questions.